Someone make it make sense.
Probably a couple.
Howdy, howdy, squirrel friends. Hope you all are having a wonderful day/evening. I've had a heck of a time today with technology being not the most fun. You know, of all the different logins and stuff that you need as a human, it's like, I feel like the one that you don't have to use that often is your Microsoft account. Like, I don't know the last time I ever had to use that for anything. Like, I didn't even know there was a login. Well, I learned today when I was trying to reach Microsoft support and contact them with a question about my computer, and it made me sign in, which then because of that, it had signed me out. Anyway, long story short, I got locked out of my Microsoft account, which basically is like your entire computer, right? Like my entire computer, being that it's Windows. So that was fun. But I hope that everybody is doing well. If you were in a hurricane zone, I hope that you guys are all safe. And we are here with the much anticipated responses here from the state, of which there's a ton. If you guys saw the thumbnail, I have a screenshot of the court filings there, sort of like, what's the right word? It's sort of like transparent, but you can see it. Anyway, there's a bazillion basically. But regarding the death penalty specifically, there's 13 responses. So we are going to go through these. And it's interesting because some of these are probably kind of like in terms of the defense motions, right? Some of these are probably more of like your standard motions to strike the death penalty. And others are actually really more specific to the facts of the case. So as we go through the state's response, as needed, we might pull up the original motion from the defense to refresh our memories. But we're going to go in order here. So you can see there's three. There's more than three. I just have three ready to go. So but we're going to go in order. So this is the first one. This is the state's objection to defendant's motion regarding non-statutory aggravating evidence. All right. So this, okay, I remember the defense, right, okay. They object to the defendant's motion for court order requiring the state to, 1, provide notice of every alleged non-statutory aggravating fact circumstance it may rely on at any sentencing trial, and 2, to prove beyond a reasonable doubt every alleged non-statutory aggravating fact or circumstance motion. I don't know why it says motion in scare quotes like that. Defendant's requested notice is already governed by IC statute, and defendant's argument that the state must prove non-statutory aggravating evidence beyond a reasonable doubt conflicts with the Idaho Supreme Court precedent. All right, Idaho's capital sentencing scheme sets the appropriate standard for notice. Idaho's capital sentencing scheme dictates the appropriate notice that each side must give for all evidence it intends to introduce at the sentencing phase in a capital case. The statute governing this special sentencing proceeding states that the state and the defendant shall be entitled to present all relevant evidence in aggravation and mitigation. The phrase all relevant evidence in the statute includes non-statutory aggravating evidence. The statute requires the disclosure of all evidence either side intends to rely on at the special sentencing proceeding in accordance with Idaho Criminal Rule 16. Defendant cites this statute approvingly, and it is unclear to the state what more defendant seeks. To the extent defendant is requesting more notice than the notice required by the statute, the court should reject defendant's request. B, the state does not have to prove non-statutory aggravating evidence beyond a reasonable doubt. Idaho's capital sentencing scheme requires the state to prove at least one statutory aggravating circumstance beyond a reasonable doubt, but it does not require the state to prove non-statutory. Okay, let me read this again because it's kind of confusing. All right, Idaho's capital sentencing scheme requires the state to prove at least one statutory aggravating circumstance beyond a reasonable doubt, but it does not require the state to prove non-statutory aggravating evidence beyond a reasonable doubt. So this is very specific to the death penalty, right? So for those who watched Chad Daybell, we heard a lot about this, death penalty case. And the whole thing with the proving of the aggravating statutory aggravating circumstances. So basically, what they're saying here is in order for the state to make the case for the death penalty to the jury, right, in sentencing, they've got statutory and then non-statutory aggravating factors. And what they're saying is that the Idaho's capital sentencing scheme requires the state to prove at least one statutory aggravating circumstance beyond a reasonable doubt. That's in order to request the death penalty, right? Or the way that the verbiage they use in Idaho is that if that is done, right? In other words, if there's at least one statutory aggravating circumstance that's been proved beyond a reasonable doubt, then the way that Idaho does it is they say that there's not a good reason to say that the death penalty would be unjust. It's languaging similar to that. So that, in other words, it's not like the jury has to vote for a death sentence. It's like they can't say that it wouldn't be unjust. It's sort of another way to go around it. And we've talked about that in other live streams. But basically, so they have to prove at least one statutory aggravating circumstance beyond a reasonable doubt, but they don't have to prove any non-statutory aggravating circumstance, or sorry, aggravating evidence, it says here, beyond a reasonable doubt. In Hall, the court reaffirmed that the fact finder in a special sentencing proceeding can consider circumstances not statutorily listed and not expressly found beyond a reasonable doubt. Moreover, the statute governing the special sentencing proceeding lays out in detail what the jury must find for a sentence of death, including that it must find the state proved the existence of at least one statutory, right, aggravating factor beyond a reasonable doubt, right. Defendant supports his argument by citing a case that provides no support at all. Tennyson did not address non-statutory aggravating evidence. It held only that the jury must be convinced beyond a reasonable doubt that any mitigating factors do not outweigh the proven statutory aggravating factors before a sentence of death can be imposed. So that actually makes sense. They're kind of taking issue with the fact that they're saying the case law that the defense cited, it wasn't really relevant because the case law cited statutory aggravating factors and their motion was for non-statutory aggravating factors. So this actually makes sense. In the first part that they were saying is that they weren't sure actually what the defense was requesting in terms of the notice right here. So, all right, we got one document down. Next up, we've got state's objection to defendant's motion to strike the future dangerousness aggravator. All right, to defendant's credit, ooh, wow, that's spicy. He acknowledges from the outset that his motion to strike the future dangerous aggravator, often referred to as the propensity aggravator, flies in the face of well-established precedent. Yeah, I was actually thinking as I was reading the title of this one, I was like, I feel like this was one of the really more interesting ones from the defense when we were going through it. Specifically, defendant acknowledges that the Idaho Supreme Court and the United States Supreme Court have upheld the constitutionality of considering propensity as an aggravator in a capital case. However, defendant dismisses with a figurative hand wave, wow, the Idaho Supreme Court's decision in Creech and the figurative hand wave, wow, and the United States Supreme Court's holding in Jurek v. Texas, both of which are binding on this court, as problematic, and plows ahead with three arguments in support of his motion. First, he asserts that the propensity aggravator fails to narrow the class of death-eligible defendants. Second, he contends that the propensity aggravator is impermissibly vague. Finally, he claims that the propensity aggravator is irrelevant to culpability. And that argument was actually my favorite part of that defense motion. It's basically like in the defense's motion in here, it was kind of like they were saying it's like circular reasoning or whatever of like, actually, maybe we'll just pull it up and look at that one part, because I don't want to misquote their argument, because their argument was really interesting. Let me see. Yeah, let me pull this up. Okay. Hopefully, yes, you guys can see that. Good. Okay. So, let's see if I can find. Okay, so it's their third argument. So let me find this here for you guys, because this was interesting. So look, it's so interesting, right? So you look at the three different issues that they took with it and how long they are going on with each issue, right? And then you can see here going back to this is the state's objection. Here they're just summarizing their first issue, their second issue, and their third issues. Okay, so this is the issue number 3, the one I was saying, which was kind of interesting. So, okay. Let me find. Okay, this court should consider the question directly. If the Eighth Amendment requires that the death penalty only be imposed on the worst of the worst whose culpability supports such punishment, how is the risk of future dangerousness relevant? The only explanation that can work within the court's jurisprudence is the pyramid analogy from Zant, but that would require that future dangerousness be considered only once the jury has found aggravators in terms of culpability, raising the defendant up the pyramid. In other words, future dangerousness cannot be an aggravator differentiating one murderer from the next. It can only operate as a consideration once a jury has found the defendant to be culpable of a crime worse than first-degree murder. So I think the main point is this question here. And this actually, I think, wasn't the argument I was thinking of where there's a lot of circular reasoning going on. That might be with the motion for the hack, heinous, atrocious, and cruel. But anyway, but this is still a similar idea here where that would require future dangerousness to be considered only once the jury has found aggravators in terms of culpability. Like, you have to find the aggravators and find them culpable of these aggravators first before you can then decide if they would be a danger in the future, right? But but where it gets to be circular here is that one of the aggravators is the future dangerousness. Does that make sense? Let me say that again. So the jury has to find culpability, right? Culpability for aggravators, right? And there's a lot of these aggravators they have. I think it's specifically 5 in this case, aggravating factors. But one of the aggravating factors is future dangerousness. So it's like, you can only determine that they're going to be a danger in the future after you've determined the aggravators. But one of those aggravators is, will they be a danger in the future? So you see, like, does that make sense? It doesn't make sense as in it should not make sense, right? Because you can't, it's like the chicken and the egg type of thing. Okay. So that was what they were saying. All right. So, A, this court cannot overrule the Idaho Supreme Court. As elsewhere in this briefing on the death penalty, defendant asks this court to enter a ruling contrary to specific holding of the Idaho Supreme Court. Right. And they're correct. You can't, that's binding. You can't overrule that. The propensity aggravator appropriately narrows the class of death eligible defendants. So a lot of what we saw in the defense's motions was about narrowing the class of death eligible defendants, because that's one of the whole things here is like, I think it's the Eighth Amendment, right? They have to narrow, the death penalty is supposed to be for the worst of the worst, right? Which is like arbitrary and subjective. So there has to be ways in which you narrow that class down, because, every crime is bad and every murder is terrible. And you know what I mean? So, and the thing is that it's tough because there's not really good objective ways to do that. And so a lot of what the defense motions were about this, many of them certain elements of them were about this particular aggravator doesn't narrow down the class. of death eligible defendants. So one of those was this propensity aggravator. So that's what they're talking about here. So the defense was saying their propensity aggravator does not narrow the class of death eligible defendants. The state is saying, we disagree. The propensity aggravator does appropriately narrow the class of death eligible defendants. So let's see what they say to support that. As noted above, defendant acknowledges that the constitutionality of the propensity aggravator was upheld by the Idaho Supreme Court. There, the court held that the propensity aggravator narrows the class of death eligible defendants and even provided an example of the type of murder that would not fall within the scope of the propensity aggravator. Ignoring the specific example provided by the Creech court, defendant claims that the Idaho Supreme Court's gloss is a list of synonyms. Oh, I remember that part with the word gloss. I remember that actually. That define anyone who would commit murder as already defined by the legislature and does not accomplish the genuine narrowing required by the Eighth Amendment. Unfortunately for the defendant, one's personal interpretation or belief about the spicy. Unfortunately for the defendant, one's personal interpretation or belief about the Idaho Supreme Court's holding in Creech is irrelevant to this court's determination. Wow. And then again, they're arguing here. The defense said it was impermissibly vague. The state saying it's not impermissibly vague. Here again, defendant acknowledges that the law is not on his side. Under his heading, there's the statute, is impermissibly vague. Defendant next writes that the United States Supreme Court held that the future dangerousness was not vague as it was something judges had to do all the time. Defendant is correct. The United States Supreme Court upheld the constitutionality of a future dangerousness or propensity aggravator. In Jurek, the court addressed an argument similar to the one that defendant poses to this court. In the Texas statutory scheme at issue in Jurek, jurors in a capital sentencing proceeding had to answer 3 questions related to aggravation in the affirmative. One of those questions was, quote, whether there is a probability that the defendant would commit criminal acts of violence that would constitute a continuing threat to society, end quote. On appeal, the Jurek defendant argued that, quote, it is impossible to predict future behavior and that the question is so vague as to be meaningless, end quote. Rejecting that contention, the Jurek court held that, quote, prediction of future criminal conduct is an essential element in many of the decisions rendered throughout our criminal justice system, end quote. And what is essential is that the jury have before it all possible relevant information about the individual defendant whose fate it must determine. I keep right-clicking on accident. And it's interesting here because the thing is this, just thinking about, just as I'm considering this in terms of the facts of this particular case, right? You know, what they're talking about here, it's propensity, right? Is the defendant going to kill again? Now, first of all, it's only logical, to me anyway, that if you feel like they could kill again, or not even kill, like they are, let's just say it could be any crime, right? But they're going to continue to commit crimes. Well, just logically, to me, having them in custody would prevent that, right? I don't really understand how killing a person is like how that's necessary to keep them from committing crimes, right? Like, does that make sense to anybody else? Y'all help me out here. Am I like, how does that make any sense? The prediction of future criminal conduct, right? That this is a death penalty aggravator, like that because they're going to commit crimes in the future, you have to kill them. I just don't understand why that's necessary. Like, if that's the case, then we need better security at the prisons, I guess. I don't know. So that's the first thing. But the second thing is that in this particular case, this is such, I agree. I agree that it's true. This is a question that is oftentimes, it is a big part of many decisions in the criminal justice system. Yes, correct, it is. But I also agree that it's a tough question. And one of the ways that people address this is with these, like they do the pre-sentencing report things or pre-sentencing investigations, where they are able to try to assess things like that. But without any of that, just going logically through it, one predictor would be past behavior, right? So, if you are in a position where you have to look at this question, let's say you're on the jury or whatever, or you're me right now, and it's like you're just considering the the relevance of this consideration of the propensity, right? Well, the one way you could assess that is just by saying, well, how many crimes have they committed, right? So in other words, somebody, if you're going to go with propensity, right? Because what do they all say? Like, prior behaviors are a predictor of future behaviors or whatever it is, which, that's not really always a fair statement because people can change and people do change. But that's a saying or whatever. So somebody who's got a really long rap sheet and has been committing crimes for decades, they're probably more likely to reoffend, right? But what's interesting here in this case specifically, as to our knowledge, is Bryan Kohberger, since he's the suspect, assessing this, he, to our knowledge, or to my knowledge anyway, doesn't have any prior criminal history at all. So there was that traffic stop or whatever. He didn't stop at a pedestrian crossing or whatever it was, but he doesn't have a criminal history, which is interesting, right? So, if indeed he's convicted of these murders, this would be the only thing. Now that is a wild thought though, right? Like your first crime right out the gate is a quadruple homicide, but anyway, okay, those are just some of the thoughts I have in terms of this propensity. So, also, I don't really know why the state of Idaho is relying so much on Texas case law, but whatever. That's not binding to this court. Defendant then argues that the propensity aggravator should be struck for the sake of clarity to the jury, arguing there is a potential for confusion where certain types of mental disorders could be taken. Oh yeah, that argument was really fascinating. That was a really good argument. I really loved that part of that argument because it was so true. Like what they were basically saying, I'll just try to summarize it. What they were basically saying with this whole thing about the mental disorders in terms of propensity, they were saying that back in the day, it used to be that like, again, I don't want to misquote them. They were saying that it used to be that like, if you had a mental disorder, that was an aggravating factor, like more likely to reoffend, but now it's like a mitigating factor. And it can't be both at the same time, which was a good point. It can't be both an aggravating and a mitigating factor. I mean, I agree. Arguing that, quote, practically speaking, every case where a jury is trying a person is likely to pose a threat of future dangerousness will involve underlying significant disturbances in that person's mental functioning. So I guess what they're saying here is like anybody who's, been convicted of a crime to where the jury is considering the death penalty has got something going on mentally, I think is what they're kind of saying. Defendant asserts that from the Supreme Court's view, a mental illness of a type that renders a person unable to understand the meaning of or reason for it bars the application of the death penalty. In support of this argument, defendant cites this case, but that case is wholly irrelevant to the defendant's argument. Interesting. So they're talking about how this defendant developed schizophrenia. The court ultimately remanded the case for a determination of the defendant's sanity, explaining that it is no less abhorrent today than it has been for centuries to exact in penance the life of one whose mental illness prevents him from comprehending the reasons for the penalty of its implications. In any event, there is nothing in the record that suggests that the defendant in this case has a mental illness of a type that renders him unable to understand the meaning of or reason for the application of the death penalty, nor is there any indication as of this time that evidence of mental illness would be presented at sentencing by either the prosecution or the defense, as neither party yet has filed notice. Yeah, that's a good point. I mean, and it is interesting because I feel like in many cases, there's some talk of mental illness, right? Whether it goes anywhere is a whole other thing, but I feel like it's usually, tossed about at some point in most cases. But yeah, good. It's reminding me that in this case, that's not even come up, it's interesting. Accordingly, this argument is wholly irrelevant or alternatively not ripe like a peach or a plum. Okay, future dangerousness is a relevant sentencing consideration. Defendant's assertion that future dangerousness is irrelevant to punishment is without merit. I mean, again, here I'm going to push back on this on a personal level because, again, like I said, what I don't understand is how saying that someone could be dangerous in the future warrants killing them, right? You guys, like, again, y'all, let me know my misunderstanding something. Like, how is it that potentially dangerous in the future, how is that an aggravating factor for the death penalty? I just don't understand. I understand that that is a factor for when you would incarcerate somebody, right? Or determine a sentence for example, LWOP versus life with possibility of parole, right? That's when we hear about these cases where there's the potential that they could get parole or they could get LWOP, right? Either one, just in recent recollection, Ezra McCandless was an example of that. And they have to consider all the different things. And one of the things is if they have the eligibility for parole, will they go out and murder people again, right? Or whatever the crime may be that they're convicted of at that point when you're determining the sentence. They've already been convicted. Threat to society. And that's where incarcerating someone would prevent that. But I just don't understand how this is an aggravating factor for the death penalty. I can't figure it out. Okay. Carrying onward here. Defendant's assertion that the future dangerousness is irrelevant to punishment is without merit. As the defendant himself pointed out in discussing Jurek, the United States Supreme Court characterized prediction of future dangerousness as an essential element in many of the decisions rendered throughout our criminal justice system. Additionally, Idaho's appellate courts place protection of society against future dangerousness. Again, y'all, do you guys see why this is insane? It's saying Idaho's appellate courts place protection of society against the future dangerousness of defense at the forefront of all sentencing decisions. I get it, but how the fuck does this mean? Sorry for my cursing. Why does this mean you have to kill people? Sorry, I just don't get it. To say somebody might be dangerous in the future, they're already going to be incarcerated for the rest of their life. They're going to be incarcerated for the rest of their life. But because if they ever weren't incarcerated, they could be dangerous, that means we have to kill them? I just don't understand it personally. Okay. As the Idaho Court of Appeals explained in blah, 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 it is clear as a matter of policy in Idaho that the primary consideration is the good order and protection of society. I can't, you guys. This just blows my mind that this is an argument here. Like, okay. All other factors must be subservient to that end. Yep, to that end, I would say incarcerating someone for life would serve that purpose of protecting society. The end. Y'all. All right, next one. We're doing good. We're on document number 3. All right, here's hack. Hack time. All right, cool. This was a good one in terms of the defense motion. So I'm just hydrating here a little bit. All right. Hack. Let's hack away at this one, huh? Get it? All right. It is well established that a capital sentencing scheme. Okay, again, I mentioned this earlier, the narrowing, right? Okay. Must genuinely narrow the class of persons eligible for the death penalty and must reasonably justify the imposition of a more severe sentence on the defendant compared to others found guilty of murder. So again, with the narrowing, just to discuss this a little bit further, it's kind of like it's all relative, right? Which is interesting that this is what we're using to decide if we're going to take people's lives or not. By we, I mean the government, obviously not me. I'll give you guys examples, right? With every case that comes around, right? When it goes to trial, maybe not every case, but a lot of them. How many times do you guys either think to yourselves or hear other people say, this is like the worst case of all time? Or you hear people say, if anybody should get the death penalty, it should be this case. If ever there was a reason for the death penalty, it should be this case. Or something like, I'm not for the death penalty, but if there's a time to use it, it's this case. How many times do you guys hear that? I feel like I hear that pretty often. And it's like the idea being that this is the worst of the worst, right? It's not going to ever get any worse than this. But then the next case comes along and you hear the same thing. So that's problematic, right? But the idea that what they're saying here is it's all relative. What they're saying, and I don't agree with this. It's just, this is what they're saying in terms of a capital sentencing scheme. That you have to decide who's worse than the others, right? What did this person do that makes them worse than the other people? Let's say you've got 100 murderers, okay? And they're all 100 people already found guilty of murder. How do you determine which murderers are worse than the other ones, right? I mean, that's really what it comes down to. Okay. In a companion motion filed contemporaneously with this one, defendant correctly acknowledges that the Idaho Supreme Court has held that Idaho's capital sentencing scheme meets that standard. As the Idaho Supreme Court explained in Wood, this court has upheld the constitutionality of its death penalty statutes on numerous occasions. Nevertheless, the defendant advances two arguments. First, he argues that the court should find that the gloss placed on the hack aggravator by the Idaho Supreme Court was in violation of the Idaho Constitution. There's a footnote. And I remember that part, and I feel like I agreed with that argument. Defendant's motion to strike utter disregard, right? Yeah, the utter disregard aggravator, right? That was nonsensical, I feel like. Second, he asserts that the Idaho criminal jury instruction for the hack aggravator does not contain the necessary limiting construction set forth by the Idaho Supreme Court. For the reasons set forth below, both of defense arguments fail. A, this court cannot overrule the Idaho Supreme Court, right? Look at that, 666. Do you guys see that? 666. Okay, here's this footnote. So defendant specifically requests that this court should find that the gloss placed on the aggravator by the Idaho Supreme. Look at that. Why can't they? Why? How? Y'all, every document that I read, I find some sort of typo, at least one, and they spelled court wrong. Incredible. Was in violation of Article 2, Section 2 of the Idaho Constitution. But Article 2 of Idaho's Constitution does not have a Section 2. Ruh-roh, that's a problem. Thus, the state presumes from the context that the defendant intended to cite to Article 2, Section 1. Okay, I see. They're saying that they must have meant to cite Section 1. Okay. All right, the constitutionality of the hack aggravator has been repeatedly upheld. By the way, just again, for anyone who hasn't already heard us talk about hack, that's heinous, atrocious, or cruel. Just oftentimes referred to as hack, right? As defendant acknowledges by his citation to State v. Osborne, the Idaho Supreme Court has upheld the constitutionality of the hack aggravator with a limiting construction. In adopting the limiting construction placed on the hack aggravator, the Idaho Supreme Court followed the standards set forth by the United States Supreme Court in Godfrey versus Georgia. Okay. The Supreme Court held, this is in Godfrey v. Georgia, the Supreme Court held that where statutory provisions concerning aggravating circumstances such as these could be applied to any murder, a limiting construction is indispensable if the state is to meet its constitutional obligation, quote, to tailor and apply its law in a manner that avoids the arbitrary and capricious infliction of the death penalty, end quote. And then I remember this part too. Okay, adopting language utilized by the Florida Supreme Court, the Osborne Court held that heinous means extremely wicked or shockingly evil. You guys see problems with this? I do. Raise your paw if you see problems with this. I mean, okay. It's so subjective. I'm not even gonna allow myself to go off on how annoying I am. Annoying isn't even the right word. This pisses me off that this is that the things like this are the basis of the death penalty in terms. Now, why do I say that? Because one of the things, remember, they have to find, the state has to prove. So far they've got 5 statutory aggravating factors, okay? For Bryan Kohberger in this case, if he's convicted, if he's found guilty, right? The state has to prove at least one of them beyond a reasonable doubt in order to ask the jury to return the death penalty or to not be able to say it would be unjust. That's how Idaho linked the language in. One of those statutory aggravating factors, one of the 5, is the hack. heinous, atrocious, or cruel. So when the jury is considering this, and this isn't just for Bryan Kohberger, this would be anybody in Idaho, right, facing the death penalty. When the jury is considering this aggravating factor, they're going to be given a definition of what heinous means. So in order to find that this factor, aggravating factor, has been proven, they first have to understand what is heinous, atrocious, or cruel. And here's the definition of heinous: extremely wicked or shockingly evil. So in other words, why this matters is because this completely subjective definition that people could have any number of ways of interpreting, one man's evil is another man's whatever, who knows? It's just, and wicked is so biblical, right? Anyway, and that doesn't actually help. That's not actually a standard. It's still so arbitrary. So, but that is the basis. They're defining heinous in this manner, and then you use that to decide if, in fact, that statutory aggravating factor has been met. It's just problematic to me, people. That's just my opinion. All right. So let's read this part again. I'm going to try to get through it without stopping, but it just pisses me off. Heinous means extremely wicked or shockingly evil. That atrocious means outrageously wicked and vile. I can't. Sorry. I tried. I tried. Are we not objection cumulative? So we've got extremely wicked, then we have outrageously wicked. I don't know why I underlined it like that, but can someone tell me what the difference is between the two? Someone please tell me, what is the difference? Oh my God, what is happening? Don't do that. What is the difference between extremely wicked and outrageously wicked? They have to be different because they're used to define two different words. You can't. Okay. Like this whole thing with the hack aggravator, I think it's so problematic, right? But the fact that there's three letters there, HAC, it's implicit here that heinous and atrocious mean something different from each other, right? Otherwise, it would just be redundant, cumulative. Heinous and atrocious have to be different. However, so is this what they're saying? Is this how they're different? Because heinous is extremely wicked and atrocious is outrageously wicked. I can't. Granted, I'll give them credit where credit is due. I'm being sarcastic. That yes, shockingly evil and vile are different. Good job there. But anyway, okay. That cruel means designed to inflict a high degree of pain with utter indifference to or even enjoyment of the suffering of others. Now that actually is an actual definition that I can stand behind. Like that actually makes sense and isn't just completely arbitrary. What is intended to be included are those capital crimes where the actual commission of the capital felony was accompanied by such additional acts as to set the crime apart. That's it. That's the whole point. Acts as to set the crime apart from the norm of capital felonies. They have to be set apart. The conscienceless or pitiless crime, which is unnecessarily torturous to the victim. That's the whole point. In interpreting this portion of the statute, the key word is exceptional. It might be argued that every murder involves depravity. The use of the word exceptional, however, confines it only to those situations where depravity is apparent to such an extent as to obviously offend all standards of morality and intelligence. Again, I think all this is insane. At first I was like, okay, good for them. Like they're saying that yes, every murder might be depraved, but there has to be something that makes it exceptional. I'm like, okay, yeah, okay, good. You're narrowing it. Good. That's what we need. We need the narrowing. And then it goes on to be what does exceptional mean? Oh, to obviously offend all standards of morality and intelligence. I take issue with that because I think, again, that completely, A, that's so vague. B, it's subjective. C, it doesn't take into account that people have different standards of morality. I mean, it's just, okay. The Osborne court explained that with a limiting construction, the hack aggravator is sufficiently definite and limited to guide the sentencing court's discretion in imposing the death penalty. Decades later, in State v. Hall, the Idaho Supreme Court affirmed the constitutionality of the hack aggravator. Yeah, I hate this aggravator personally. The court held that the appellant had provided no basis, principled or otherwise, to support his vagueness challenge, and noted that the hack aggravator has been determined constitutional time and time again. Yuck. Okay. Let's just see. Let's see if we can get to the point here. Okay. The ICJI for the hack aggravator appropriately reflects the case law. So this is the jury instructions. Defendant argues that the instruction for the hack aggravator does away with the additional proofs set forth in Osborne. That is wrong. A comparison can be found below. These are the jury instructions. I hate this so much, you guys. This is the instructions that if you're in Idaho, okay, and you serve on jury and it's a death penalty case, these are the instructions you're going to be given for this aggravating factor on the right-hand side here. I hate it so much. Okay. But they're right. I agree with the state here in that it doesn't look like anything is really missing compared to the case law. So I'll give them that. All right. All right. Next up. What's next? What's next on the docket? So we are on. All right. We're on the multiple victims aggravator. Okay. Here we go. One thing I will say is that, when covering the defense's motions for each of these, each one was like a bazillion pages long. At least in terms of just from a purely logistical, practical time standpoint, it's nice that these are a bit shorter in terms of the state's response. It just makes it, more likely to get through them all. So, okay. State's objection to defendant's motion to strike multiple victims aggravator. So this would be just thinking about, again, these aggravating factors for the death penalty. This one seems less vague, right? Of the ones so far that we've gone through tonight. Like there was more than one victim. Yes, I don't think anyone's going to argue there was not more than one victim. This at least seems like more objective, right? Like either there was more than one victim or there wasn't, but let's see what they say here. Argument. Defendant does not make a legal argument in his motion to strike the multiple murders aggravator. Instead, he attempts to craft a public policy argument. Unfortunately for the defendant. And it's funny because I'm trying to remember, I feel like in the defense's motion to strike this, I thought they made a good argument. But I don't remember what it was specifically. Let's see. Defendant is referring to Idaho Code blah, 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 which applies when at the time the murder was committed, the defendant also committed another murder. Right. I think their argument was that it assumes that they've already been found guilty of murder, which is impossible or something like that. Let's see. Unfortunately for the defendant, there is no legal authority that supports his motion. Defendant claims murders cannot be aggregated in a matter that makes the act of malice aforethought murder aggravated. This might have been one of the ones where it seems like there was a circular circular reasoning in terms of finding this aggravating factor. He boldly asserts, quote, there is no way in which two murders can be aggregated in a way that makes the act of murder aggravated except to resort to one of the other aggravators. In support of this contention, he does not cite a single statute or appellate case, but rather an article from the New York University Review of Law and Social Change. That article does not even stand for the proposition that the defendant claims it does. The article does not argue that multiple murders is not an appropriate aggravator in a capital case. Rather, the article analyzes a study on capital cases in Texas and the extent to which non-legal considerations play a role in prosecutor and jury decision-making. The article is summarized as follows. Put another way, the article specifically refers to multiple victims as one of the legally relevant factors to consider in capital cases and further states that death penalty sentences are fairly and equitably imposed when such factors consistently form the basis of decisions to impose the death penalty. If this article can be read to present any opinion at all on the multiple murders aggravator, it is that it is a fair, legitimate, and appropriate consideration in a capital case. Double counting. Okay, this might have been the part of the defense's motion that I thought was strong, that I resonated with here. The defendant further asserts the multiple murders aggravator violates Idaho Supreme Court's prohibition on double counting. Yeah. Okay, let's see what they say here. In Abdullah, the Idaho Supreme Court simply reiterated the well-established standard that double counting or double weighing aggravators is impermissible. In this case, the state intends to present evidence that would allow a reasonable jury, to find all statutory aggravators without engaging in impermissible double counting by presenting additional evidence for each statutory aggravator. Further, there is no reason to doubt that the jury will be instructed that they may not double count or double weigh the evidence. Idaho Criminal Jury Instruction 1723 addresses this very issue. The state has alleged more than one statutory aggravating circumstance in this case. You must consider whether the state has proven the existence of more than one statutory aggravating circumstance beyond a reasonable doubt by relying on the same facts or independent facts. The same facts without more cannot be relied on to find more than one statutory aggravating circumstance beyond a reasonable doubt. So they can't, right. Okay, now I remember why I thought this was a good argument from the defense. Right, okay. This is interesting. This is important to note, guys. So they can't use, I remember, because this is all coming back to me now. They can't use the same set of facts for more than one aggravator, which is interesting. So in other words, okay. So in other words, the fact that he killed 4 people, okay, sorry, let me rephrase that. This is based upon the premise that he's been convicted and found guilty, right? Because this is about sentencing. So with the assumption that in this case, since we're talking about, this would be for the sentencing phase, this is in the case that he's been found guilty, right? If that's the case, he will have been found guilty of killing 4 people, right? So you can't take that fact and use it for more than one aggravating factor. So in other words, if you use the aggravating factor of multiple victims, then you cannot take the multiple victims and use that in any of the other aggravating factors. For example, the hack, heinous, atrocious, or cruel, right? Or any of the others. You have to have a completely different set of facts for each aggravator. So that's just interesting to keep in mind. So independent facts must exist for each statutory aggravating circumstance in order for you to find that the state has proven multiple statutory aggravating circumstances beyond a reasonable doubt. And remember, they only need one in terms of by law, right? We covered that like at the beginning of the stream, how they have to have, the state has to prove one aggravating factor, statutory aggravating factor beyond a reasonable doubt in order for the jury to consider that they can't rule out the death penalty, basically. Thus, any argument that the jury would disregard the instructions provided to them and engage in impermissible double counting is purely speculative. Oh, that's funny. What? Huh, that's interesting. So I interpreted this as the state has to follow the rules and provide has to use different facts for each aggravating circumstance. And now the state is like, it's the jury's job to follow the instructions. They're not going to disregard the instructions. Anyway, it's interesting. I feel like putting the responsibility on the jury when I feel like it should be on the state. That's my opinion. All right. So, okay. So that's their conclusion. They're saying get rid of that one. Yeah, it's interesting. Again, this is just the defense's. The defense made good points in some of these motions, and this was one that I thought was a strong one when it came to the double counting part. So, okay, we're on to the next document. So that will be the utter disregard. This was another one that was well, let's see what you guys think. There we go. Okay. So we did this one. So this is, I believe, the 5th. Let me double check. 1, 2, 3, 4. I thought there were 5 statutory aggravators. Maybe there's just 4. There's the future dangerousness, the hack, multiple victims, and utter disregard, I think. Unless some of these are out of order. I'm just looking at the list of all the court filings here. But yes, okay. So this might be the last one then in terms of the statutory, the motions to strike these different statutory aggravating factors. So, all right. The utter disregard. So state's objection to defendant's motion to strike utter disregard aggravator. So this is another one where we're probably going to get, utter disregard, right? So this is the utter disregard for human life. And I can already say, can you guys see how there's a problem here? Like, is there an overlap? How is this different from hack? You have utter disregard. This is the separate aggravating factor, right? And remember, these have to be based on completely different sets of facts. So the state will have to prove that there's some set of facts, and it can't be the multiple victims, right? Some set of facts that make it heinous, atrocious, or cruel. We went over that a few minutes ago. And then another completely separate set of facts from all of those that shows an utter disregard for human life. All right. And also, how are they going to define it? Let's see. Okay. In this case, the state is pursuing the utter disregard aggravator. The aggravator applies when, quote, by the murder or circumstances surrounding its commission, the defendant exhibited utter disregard for human life. Right. We said that already. It is well established that a capital sentencing scheme must, again with the narrowing, genuinely narrow the class of persons eligible for the death penalty and must reasonably justify the imposition of a more severe sentence on the defendant compared to others found guilty of murder. I will say one thing that I think is valuable that hopefully you guys are getting out of covering these from when we did both the defense's motions and these is I feel like we're getting a really good lesson on how this works, right? In terms of the law, at least in the state of Idaho. That the point is to narrow the worst of the worst, right? But then how do you determine the worst of the worst? That's really kind of how this whole thing gets started, right? So yeah, okay. Defendant correctly acknowledges that the Idaho Supreme Court has held that Idaho's capital sentencing scheme meets that standard. As the Idaho Supreme Court explained in Wood, this court has upheld the constitutionality of its death penalty statutes on numerous occasions. Nevertheless, defendant argues that the court should strike the utter disregard aggravator, asserting that this court should hold that the judicial gloss placed on this aggravator was unconstitutional. Defendant also argues that the court should strike the utter disregard aggravator because the Osborne construction does not appear in standard criminal jury instruction. The court should deny his motion. Okay, again, this court cannot overrule the Idaho Supreme Court. The defendant makes an extraordinary request of this court to find that the gloss placed on the aggravator by the Idaho Supreme Court was in violation of the Idaho Constitution. This, of course, the court cannot do. The Idaho Supreme Court unambiguously set forth its authority in State v. Guzman. To this court falls the obligation to be and remain the ultimate authority in fashioning, declaring, amending, and discarding rules. And again, we saw this on another document here that they referenced the wrong article number. But anyway, okay, so to this court falls the obligation to be and remain the ultimate authority in fashioning, declaring, amending, and discarding rules, principles, and doctrines of precedential law by application of which the lower courts will fashion their decisions. This court has been and remains the final arbiter of Idaho rules of law, both those promulgated and those evolving decisionally. Because defendant's argument that the court should hold unconstitutional the Idaho Supreme Court's construction set forth in Osborne requires this court to effectively overrule a higher court, the court should disregard it outright. The constitutionality of the utter disregard aggravator has repeatedly been upheld. Yeah, right. And like I said, right, to me it is vague, but here they're saying the Idaho Supreme Court has held that the utter disregard aggravator is not unconstitutionally vague. Please let me, how? Explain it to me, state. Explain it to me. The Osborne construction satisfies the Eighth Amendment by genuinely narrowing the class of persons eligible for the death penalty. How? How? In Creech, the United States Supreme Court found that it was not necessary to determine whether the phrase quote, utter disregard for human life, end quote, itself was sufficient to pass constitutional muster because, the court explained, the Idaho Supreme Court has adopted a limiting construction and we believe that construction meets constitutional requirements. Oh, God, this just sounds like no one wants to answer the question. Are you guys getting that? Like, oh, God. It just sounds like they're just like dodging the question of defining it. We'll see. As recently as 2018 in State v. Hall, the Idaho Supreme Court reiterated that Idaho's utter disregard aggravator has also been repeatedly, like they're just saying, dude, y'all, they're just saying it's been deemed constitutional. So it is. It's constitutional. It's fine. It's constitutional. You see? Blah, blah. But like no one's explaining how or why. Frustrating. Hope maybe they will. Let's see. We're on page 4. We'll see what happens. Defendant's argument that the Idaho Supreme Court's decision in Verska versus St. Alphonsus Regional Medical Center reversed its ability to provide judicial interpretation to statutes is self-evidently wrong. So basically, they were citing this other case here to say that you could provide, how am I trying to say this? That you could find things differently than what from statutes. Like you could find a different interpretation is what it seems like it's saying here. In State v. Abdullah, decided after Verska, the Idaho Supreme Court again reiterated the propriety of using a limiting construction, holding that the utter disregard aggravator with a limiting construction is not void for vagueness under the 8th Amendment. How? Ugh. Everybody just keeps saying, yeah, we decided it's fine, but no one's saying, well, how or why. Anyway. All right. The jury instruction for the utter disregard aggravator appropriately reflects law. Defendant claims that the jury instruction for the utter disregard aggravator only makes matters worse because it too closely tracks to the hack aggravator. Hey, that's what I said. One need only look to the respective jury instructions for utter disregard and hack to see that they are distinct. Oh boy. Idaho criminal jury instructions are available at blah, 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 blah. Defense argument has been foreclosed by the case law. The Osborne court specifically held that because, quote, we will not presume that the legislative intent was to duplicate any already enumerated circumstance, that the phrase utter disregard must be viewed in reference to acts other than those set forth in the other statutory aggravators, unquote. The Osborne court, oh boy. The Osborne court then crafted its limiting construction to reflect, here we go, guys. Here's the utter, here we go. We're getting a definition. What does it mean? Utter disregard. What does it mean? Okay. How is it different from hack? Here's our answer. Quote, the highest, the utmost callous disregard for human life, i.e., the cold blood, pitiless slayer. You guys. Hold on. It's just, I can't go on without goading anymore. I've held off as long as I can. Just because, let's just do this for fun too. Let's just pull up again that part that just drove me to the depths of insanity. Where was it? Okay, let me pull this up. Wow, I just don't even know. It was where they gave the definition. Right. So, okay. Remember, so here's hack. Heinous is defined as extremely wicked or shockingly evil. Atrocious, again, a different word, means outrageously wicked and vile. And then, not to mention, as we're reading along here, cruel means blah, 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 with utter indifference to. Utter indifference to, or even enjoyment of the suffering of others. So here, cruel is defined as utter indifference to. So right there, how is that not redundant then to utter disregard for human life? And then again, with just the subjective biblical type. I mean, the cold blood pitiless slayer. It's tough for me. It's tough for me. And this is what the jury is given to decide someone's life or death. I don't know. I mean, I'm at a loss for words. I'm not going to goat again right now. I've got my goat in hand, ready in case I need it, though. My comfort goat. Okay. Even if the other disregard aggravator has some similarities to the hack aggravator, well, at least they're conceding that the state can still proceed on both. Now, remember, okay, yes, they can. But remember, guys, they have to use a completely different set of facts for each. They can't overlap on the facts, which is interesting, right? Similarly, defendant claims that the jury instructions completely ignores the legislature's intent and rewrites the statute. The legislature describes a person taking a killing action recklessly. Defendant is wrong. That's an entire sentence. Defendant is wrong. Nowhere in Idaho code, blah, 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 did the legislature use the word reckless, despite using it in two other subsections setting forth aggravating circumstances. Okay, these are examples where they do use the word reckless. I'm not going to read all that. If the legislature intended to encompass recklessness, it would have said so explicitly as it did elsewhere in Idaho's capital sentencing scheme. Conclusion, it should be denied. Blah, blah, blah. Okay, what is next? What is next? So there's a couple filings here, objections to expert testimony. I'm not going to cover those tonight. I'll probably do those on a different stream. Because I'm wanting to deal with just the death penalty stuff tonight because there's so many. Okay, so next up is objection. Where is it? State's objection to defendant's motion to strike notice of intent to seek death penalty on grounds of failure to present aggravators to a new. Right. Okay, so. So these are, I guess, what you could say are probably your more run-of-the-mill or commonplace motions to strike the death penalty. So you've got a couple different things going on, right? You've got motions to strike those different aggravating factors, which we already covered. Statutory aggravating factors, right? And I guess this is kind of confirms that there's 4 of them. There's the hack, utter disregard, multiple victims, and future dangerousness. Those are the 4 that the state's going with, okay? So they've got the defense has a motion for each of those, right? Then they've got these other sets of motions, which are just more like just to strike the death penalty as a whole, right? In this case, not just the individual aggravators, but the entire thing. So state's objection to defendant's motion to strike notice of intent to seek the death penalty on grounds of failure to present aggravators to a neutral fact finder. The thrust of the defendant's argument is that the applicable aggravating factors in a capital case must be presented to a grand jury. His argument is squarely foreclosed by binding Idaho Supreme Court precedent. Both Article 1, Section 8 of the Idaho Constitution and the 6th Amendment of the United States Constitution require the state to provide notice to the accused of the crime charged by indictment or information pursuant to Idaho law. The state must include in the information or indictment, quote, a plain, concise, and definite written statement of the essential facts consisting of the offense charged, end quote. In a capital case, the state must also provide notice to the accused of the intent to seek the death penalty within 60 days of the entry of a plea. So basically, what this is about is they're saying, okay, you guys remember how there's been these other defense motions in the past that were kind of funny, like the Magna Carta and all that, right? Like the whole thing about the grand jury. This to me is kind of along those lines in terms of from the defense's motion, where what they're kind of saying is that the neutral fact finder, when they're referencing a neutral fact finder, what they're saying is that the decision to seek the death penalty should have been presented to a grand jury, and that would be the neutral fact finder, and that didn't happen, and that's violating, whatever they're saying it's violating, the Constitution, I guess, Idaho Constitution. Yeah, Idaho Constitution. Right. And that's one of those. This is one of those arguments I don't think is going to go very far, and so okay. Yeah, the Idaho Supreme Court held the aggravators do not have to be presented to the grand jury, right? So yeah. that's pretty much, it is what it is. This is, yeah, there's no constitutional requirement that the state present evidence demonstrating probable cause for each aggravating circumstance. Yeah. I mean, that is what it is. Okay. So next one up here is, okay, so now we're going to go to the international law. All right. Cool. I'm just going to try to make sure I know what's happening here. Okay, we're on this one. So, state's objection to the defendant's motion to strike notice of intent to seek death penalty on grounds of international law. International law, people. All right. The defendant's motion is made with no legal authority to support his position and should be denied. Now, I have to say, even if you have the right argument or the right idea or whatever, y'all know by now, hopefully, if you don't cite legal authority, good luck. I mean, it's just not going to happen. So that's a problem. That's a problem. The defendant argues that Idaho's death penalty scheme violates the International Covenant of Civil and Political Rights, which was ratified by the United States in 1992. The ICCPR prohibits cruel, inhuman, or degrading treatment or punishment and prohibits the arbitrary deprivation of life. However, the ICCPR also states, in countries which have not yet abolished the death penalty, sentence of death may be imposed only for the most serious of crimes in accordance with the law in force at the time of the commission of the crime and not contrary to the provisions of the present covenant and to the Convention on the Prevention and Punishment and of the crime of genocide. This penalty can only be carried out pursuant to a final judgment rendered by a competent court. Therefore, the ICCPR has not completely abolished capital punishment, but in countries that continue to allow its imposition, permits capital punishment for the most serious crimes. Additionally, as the defendant points out in his own motion, the United States carved out an exception specifically for the death penalty when it ratified the treaty. That the United States reserves the right, subject to its constitutional constraints, to impose capital punishment on any person other than a pregnant woman. Interesting. Y'all, I did not know that. Other than a pregnant woman. Huh. They can't put a pregnant woman to death, it sounds like. Wow. Duly convicted under existing or future laws permitting the imposition of capital punishment, including such punishment for crimes committed by persons below 18 years of age. And actually, see, now I'm thinking about it. I'm like, that makes sense, right? Because then it's like technically they'd be killing the baby, right? And that would be illegal. So I guess they have to wait for her to give birth and then they do it. I don't know. Interesting. I don't know how often this comes up, but it's interesting, isn't it? Including such punishment for crimes committed by persons below 18 years of age. I wonder how often does that happen? Or, I mean, it's hard to fathom, right? It's hard. My brain's like not computing. What this is saying is that it's still okay for them. Sorry, I'm having a hard time computing again. The U.S. can kill people under the age of 18. Like they can do it. Like it's allowed. Wow. The U.S. reserves the right to give the death penalty to people under 18 years of age. I can't even wrap my head around it. Okay. I don't think that happens very often, thankfully. That the United States considers itself bound by Article 7 to the extent that cruel, inhuman, or degrading treatment or punishment means that cruel and unusual treatment or punishment prohibited by the 5th, 8th, and or 14th Amendments to the Constitution of the United States. I mean, since we're on the subject here of cruel, unusual treatment and punishment, it's interesting, right? Because it's like, well, cruel and unusual treatment is one of the things that was outlined in, what was it? The utter disregard aggravator, which is an aggravator to give someone the death penalty, right? But of course, the death penalty itself, in some places, in terms of international law, has been ruled to be itself cruel and unusual treatment or punishment, right? It's just the irony. All right, so by doing this, the United States unambiguously reserved the right to impose capital punishment in accordance with the 5th, 8th, and 14th Amendments, blah, blah. The court should decline the defendant's invitation to entertain this novel and unprecedented theory and instead follow the example of another Idaho district court that recently denied a similar motion. As the district court in State v. Richard Ross aptly explained, the clear weight of both the United States and Idaho Supreme Court authority shows the legality of the death penalty under appropriate circumstances. To craft an outright prohibition based on interpretation of language in an international treaty would circumvent that authority, to say nothing of the authority of the Idaho legislature. All right, what's next? Where's my arrow? Arrow, where are you? Oh, okay, so there it is. Sorry. Okay. Oh, good. Next is the vagueness one. Ooh, I loved these ones. So we've got vagueness, and then we have arbitrariness. Good. I love it. Here's the thing. Some of you guys might already know this, but for those of you guys who don't know this, I love philosophy, and I studied some philosophy in college. And it's so interesting because a lot of times I find that the law and philosophy overlap. And that's where I really actually enjoy. I enjoy everything about the law, but I really enjoy some of the thought exercises. And so some of this stuff, like we've been talking about tonight, but for example, the arbitrariness, the vagueness, the circular reasoning, all that really I find fascinating. So that's why I got excited when I saw that these were the next ones coming up on the list. All right. State's objection to defendant's motion to strike. State's notice of intent to seek the death penalty on grounds of vagueness in balancing aggravators and mitigators. Despite its name, defendant's motion does not address his alleged vagueness in balancing aggravators and mitigators. Instead, he asserts a facial challenge to the methods of execution used in Idaho. Oh, right. Okay. So I'm remembering. So this was the motion from the defense because, again, there's so many of them. This is the one that talked about the methods of execution and that, right. Because there's a lot of issues. People might already be aware, but for anyone who's not aware, the Idaho just recently allowed the firing squad or whatever, but it went through the different methods that can be used for, killing a person and how all of them, if I'm thinking of the right one, it's like all of them basically constitute cruel and unusual punishment and are therefore unconstitutional. So, but then again, one could also argue that taking of one's life in any manner, the government or a citizen taking another person's life in any manner is unconstitutional, right? Depriving someone of their right to exist. Anyway, this court should deny his motion because it is 1, not ripe for adjudication, 2, foreclosed by U.S. Supreme Court precedent, and 3, insufficient on its face for a method of execution claim. Right, method of execution. Right. So I was on the right track with that. They're talking about the methods of execution. All right. Defendant's method of execution claim is not ripe for judicial review. The court should refuse to consider the defendant's claim at the stage of his proceedings because it's not ripe for adjudication. The doctrine of ripeness acts as a practical limitation on the jurisdiction of Idaho's courts to resolve disputes. Ripeness asks whether there's need for the court action at the present time. So I think what they're saying here is it's too early to be just talking about this, right? Because this would come up later. Under the ripeness test in Idaho, it's funny, the terminology of ripe, I think, is interesting here. All I can think about is a peach, Under the ripeness test in Idaho, party must show 1, the case presents definite and concrete issues, 2, a real and substantial controversy exists, and 3, there is a present need for adjudication. So I think I see what they're saying here, and I would agree that there isn't a present need for adjudication here because he's not up for the death penalty yet. I mean, in other words, it's too early to be, going over this. I think that's what they're saying. Right. The claim becomes ripe when the method is chosen. Yeah. No, that makes sense. That does make sense. Especially because the methods, it could be different by the time, this is so far in the future. This court has found that when an execution date has not been set, right, it is premature to consider a claim involving the method of execution as the type of lethal right. The type of lethal injection the state may use in the future is unknown. Yeah. Now, I don't think that that's necessarily a good thing. I think that in some ways that could be worse. But I understand what they're saying because you can't really make the argument if you don't have the information. Defendant speculates that if he is convicted and sentenced to death, and if the law in Idaho is still the same when it comes time for his execution, then he will be executed by the firing squad because lethal injection will not be available. He supports conditional and speculative assertion by citing the Idaho Department of Corrections attempted right. That whole thing was horrifying. I'm not going to even go over that. But differently, defendant asserts lethal injection will not be available for him decades from now because earlier this year, well, they're being hypocritical here, and I'll tell you why. They're saying this is speculation, blah, blah. Well, they're speculating when they say decades from now because no one knows how long it would be. Yeah, I mean, decades, right? It could, may or may not be. We don't know. Anyway, moreover, given the decades, again, I can't stand hypocrisy, guys. It's just, I can't, I have no tolerance for it. Moreover, given the decades of time that would pass between the imposition of a death sentence and any execution, there would come a time before any execution when this court or another court will be in a better position than we are now to decide this question. For example, neither this court, defendant, nor the state can accurately predict whether and to what extent there will be changes over the next several decades. Okay, yep, it's not right. We get it. All right. Defendant's method of execution claim is foreclosed by U.S. Supreme Court precedent. Well, this is all basically the same thing. Oh, this is about whether they're constitutional or not. That's what I was saying a second ago. Right. Capital punishment is constitutional. How? How, though? Is this going to be one of those things where they say it's constitutional because they're like, it's constitutional because it is. Like they did with that other thing earlier? I can't. Y'all? All right. It necessarily follows that there must be a means of carrying it out. Okay. Guys, what they're saying is, okay. What they're saying here is that capital punishment is constitutional. Not really backing that up, but even if you go ahead and accept that, what they're saying is that then it means that necessarily there must be a means of carrying it out. So are they jumping to the whole conclusion that therefore whatever that means is must be then constitutional? Because please tell me that's not the case. Please. While the U.S. Supreme Court has, quote, never invalidated a state's chosen procedure for carrying out a sentence of death as the infliction of cruel and unusual punishment, that's insane to me. The High Court has affirmatively approved certain methods of execution, including lethal injection and firing squad. Ugh. The court first approved lethal injection in Bays and cleared any legal obstacle to use of the most common 3-drug protocol. This is the part that pisses me off. That enabled states to carry out the death penalty in a quick and painless fashion. Part of me wonders if the powers that be would like to believe that it's quick and painless so that they can, whatever, like, I wonder if that's a part of it, like subconsciously, if like they want to believe that it's quick and painless because we know it's not quick and painless. We know it's not quick and painless. The other thing that's interesting, right, is that some people that are advocates of the death penalty would say that the reason, if you were to ask someone who's an advocate of the death penalty, and ask them why, on what basis, why do they advocate for it? I would imagine many people would say because it's given, just they want the person to suffer, right? Because some people will make the argument that they would actually suffer worse if they're given LWOP, right? So there's an element there of vindictiveness, like wanting a person to suffer. But what's interesting, right, even though that's what some people might say if they're advocating the death penalty, what's interesting is like inflicting intentional suffering is unconstitutional. So it's not oxymoron. Like the government can't do that. That's torture. The government can't intentionally inflict suffering. So it's ironic, right, that they have to. Wow. Okay. So they have to, in order to be the least unconstitutional as possible, right, when executing someone, they would have to do it in a way that is quick and painless, right? Which again is interesting because some people that advocate for the death penalty would advocate for it, saying they want someone to suffer. But again, technically, it's not supposed to make them suffer. But then the other part of this that is so ironic is that we know that it does make them suffer. It's not quick or painless, but yet they call it quick or painless so that they can say it's not unconstitutional. Do you guys see all the elements, all the layers of this, how this is just so messed up? Like, it's wild to me. It's wild to me. There's just, I feel like there's so much like suspension of disbelief or things that have to go on in order to even, again, like I was saying initially, people that want to tell themselves it's quick and painless so that they can then say, well, it's not unconstitutional. But they know it's not quick and painless. Anyway, all right. The court has also observed and cited approvingly a list of, quote, courts across the country that have held that the use of pentobarbital in executions does not violate the Eighth Amendment. Finally, the court approved the use of midazolam. I don't actually know much about that specific drug. Don't really want to know because it's always horrifying to learn. Defendant acknowledges that Idaho's execution protocol would not allow for the use of any other chemicals for lethal injection. And he fails to argue that any specific aspect of Idaho's protocol would take it outside of these determinative decisions. Bayes and Glossop thus foreclosed defense argument as to lethal injection. Similarly, the court has approved the use of the firing squad to conduct executions. Oh, God. I'm sorry. I'm having flashbacks to reading that motion where they talk about the firing squad. As horrific and harrowing as it was to read that, it was interesting to note, and I'll just summarize some of the things that I recall taking away in terms of just, learning, right? What's interesting, guys, and I don't know why this is the case, but they have to shoot for, just so you guys know, without having to read how horrible some of the things are that were cited in that motion, I'll just tell you, they have to shoot for the heart. I didn't know this. They have to aim for the heart, not the head, the heart. Why? I have no idea, but that's what they have to do. And there was also the type of weapon they were using. I can't remember what it was, but the type of weapon they were using was like not the type that would be the quick, like, there's some guns. Anyway, it was like, I remember, I don't know much about guns, but I remember reading about it and being like, oh my God, that's the type of gun they're using. Like, what? But the thing about that they have to shoot for the heart is wild, because the thing is that I don't understand it. I don't know why they don't shoot for the head, or that's not what they're supposed to do. Because I mean, again, it's depressing, so I'm not going to pull it up, but like it talks about how, and most people probably would know this anyway, if you shoot for the heart area, right? It's like, even if you get it correct, it's not an instant death like it would be shooting in the head. It's not an instant death. And like, oh God, they gave examples of where people actually live for a considerable period of time if being shot in the heart, quote unquote. Anyway, I have to just move past it because it's just really upsetting for me. I don't know why they don't, if they're going to shoot them in the, I mean, it's awful to say, right? But like, I don't know why they are shooting in the heart and not shooting in the head. It makes no sense to me, but that's what they do. Okay. But it's important to know that, right? In terms of, when we're having these conversations about the death penalty, especially with the firing squad, it's important to know that that is part of it. They shoot for the heart, not the head. Okay. Defendant's method of execution claim is insufficient on its face because he failed to identify an alternative method of execution. Even setting aside defendant's problems with justiciability and dispositive precedent, he has gone about his Eighth Amendment claim all wrong by failing to provide an alternative method of execution. Well, According to your own argument, though, state, it's not ripe to even be discussing it, right? Again, I can't stand the hypocrisy. The Eighth Amendment does not guarantee a prisoner a painless death, something that, of course, isn't guaranteed to many people, including most victims of capital crimes. Instead, the Eighth Amendment forbids only methods of execution that seek to superadd terror, pain, or disgrace to the execution. Again, it's not supposed to make them suffer, right? And as the unique verb superadd suggests, this is a necessarily comparative exercise, of course, right? Of course it is. To decide whether the state has cruelly superadded pain to the punishment of death isn't something that can be accomplished by examining the state's proposed method in a vacuum, but only by comparing it, right, with a viable alternative. Thus, identifying an available alternative is a requirement of all Eighth Amendment method of execution claims alleging cruel pain. Further, the identified alternative must be readily implemented and significantly reduce a substantial risk of severe pain. Defendant's attack on lethal injection and the firing squad is insufficient on its face because he failed to take a single step down the high court's well-lit path interesting, for method of execution claims. In 16 pages of briefing, defendant failed to even mention an alternative method of execution, much less prove a readily available alternative that would significantly reduce a substantial risk of severe pain. That is a third independent reason why the court, this is weirdly written, I feel like here. Okay, all right. There we go. Failed to produce another method. All right. Next. I think we are on arbitrary. Although what's weird to me, though, is that why are we... Yeah, do that. Okay. What's weird to me, though, is how the heck? Because wasn't this supposed to be about vagueness? It was. Interesting. Okay. So we are on the arbitrary one. Okay. State's objection to defendant's motion to strike state's notice pursuant to Idaho code, blah, 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 on grounds of arbitrariness. Arbitrariness. All right. Citing a law review article, defendant asserts two challenges to Idaho's capital sentencing statutes. First, defendant claims Idaho's capital sentencing statutes do not sufficiently narrow the class, as we've talked about, of convicted first-degree murderers who are eligible for the death penalty. Second, defendant argues that Idaho's capital punishment scheme is unconstitutional because of alleged geographic disparities. The Idaho Supreme Court has rejected both arguments. Even if there were some legal basis for defendant's arguments, the law review article he cites does not reliably support his arguments. So their first statement here, argument rather, Idaho's capital sentencing statutes narrow the class of persons eligible for the death penalty as required by the Eighth Amendment. Guys, I have to get some more water. I'm going to put on some music. I'll be back in just a second. I don't have any videos queued up, and there's not any videos relevant anyways, because we're just doing documents. So let me just put some music on. I will be right back in a second. I'm just going to get some more water because it definitely, you have to stay hydrated when reading all these documents. You know what I mean? So let me put on some night driving. It'll just be a second. I just want to give you guys something to at least listen to while I go get some more water. Okay. Okay, I'm back. Excellent. All right, so where were we? Yes, Idaho's capital sentencing scheme complies with the Eighth Amendment's narrowing requirement. Capital punishment, quote, may not be imposed under sentencing procedures that create a substantial risk that punishment will be inflicted in an arbitrary and capricious manner. To avoid arbitrary application, a state's capital sentencing scheme must genuinely narrow the class of persons eligible for the death penalty. Right. Most states, including Idaho, have chosen to narrow the class of persons eligible for the death penalty by requiring the jury to find the presence of at least one aggravating circumstance. And so we talked about that earlier. Each aggravating circumstance may not apply to every defendant convicted of murder. It must apply only to a subclass of defendants convicted of murder. Again, the whole premise that, the worst of the worst, right? Only the worst of the worst. So we have to figure out how we determine that is the whole thing. The question of whether a state's capital sentencing scheme properly narrows the class of persons eligible for the death penalty is qualitative, not quantitative. In Hall, the defendant challenged the felony murder aggravating circumstance on the basis that it did not comply with the narrowing requirement. The aggravating circumstance applied to those murders that are committed in the perpetration of arson, rape, robbery, burglary, kidnapping, or mayhem. Mayhem? The court acknowledged that this language may apply to many murders, but nevertheless found it past the narrowing requirement because it certainly does not apply to every first-degree murder, which is all the narrowing required by this case law. Even assuming it is appropriate to aggregate the aggravating circumstances when alleging insufficient narrowing, and even assuming defendant's law review article accurately, they're really making fun of this whole law review article thing, accurately portrays the number of first-degree murders that are eligible for the death penalty in Idaho. According to defendant's study, the combination of all the aggravating circumstances may apply to many murders, but it does not apply to every first-degree murder, which is all the narrowing required. They already said that. Moreover, a defendant is not the first to try to aggregate the aggravating circumstances in Idaho, and it did not end well for the first person. Whoa, what does that mean? It did not end well? What? Like what? The defendant in Hairston argued that the combination of all the aggravating circumstances in Idaho code, blah, 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 apply equally to all first-degree murder defendants and thus failed to provide a meaningful way to distinguish between those who deserve capital punishment and those who do not. The defendant urged the court to conduct a review of all Idaho first-degree murder cases to analyze the aggregate effect of Idaho's aggravating circumstances, but the court refused, finding no legal basis for such a review. Rather, the court held that the aggravating circumstances are to be considered individually, not in the aggregate. Each aggravating circumstance must provide a principled basis for distinguishing between those who deserve the death penalty and those who do not. Because the defendant did not challenge a particular aggravating circumstance, the court refused to find the Idaho's death penalty scheme as a whole to be arbitrary or capricious. What do you mean it didn't end well? They just denied it, which is what you're saying they should be doing here. Anyway, that was a bit dramatic, state. The Idaho Supreme Court's decision to reject aggravating circumstances put the court in good company. It's a bunch of tongue twisters with these aggregating and aggregators. We find the relevant inquiry to be whether the sentencer fairly could conclude that an aggravating circumstance applies to every defendant eligible for the death sentence, not whether taken in combination. Delaware's statutory aggravating circumstances apply to virtually all defendants convicted of first-degree murder. Moreover, defendants' myopic focus on statutory aggravating circumstances ignores other mechanisms in Idaho's capital sentencing scheme that help perform the necessary narrowing. After all, the use of aggravating circumstances is not an end in itself, but a means of genuinely narrowing the class of death-eligible persons and thereby challenging the jury discretion. Channeling the jury discretion, sorry. Okay, take, for example, a mentally ill individual who kills multiple people at once. Even though the state would have no problem proving the multiple murder aggravating circumstance, the perpetrator would not be eligible for the death penalty in Idaho if the mental illness were severe enough that the imposition of the death penalty would not be just. In that and many other potential scenarios, the requirement for the jury to weigh all the mitigating circumstances narrows the class of death-eligible persons. Defendants' refusal to consider this additional narrowing aspect of Idaho's capital sentencing scheme is likewise fatal to his argument. I mean, I don't know if that's appropriate using the word fatal when we're talking about death penalty, but whatever, state. Oh, the geography. That was an interesting one. Sentencing based on the geography. That was really interesting. That was like we got a whole history of the geography, and it was interesting. It's not, I don't think it's going anywhere. I'm not too worried about reading all this because it was really more, again, just interesting from a historical standpoint. And then again, they're poking fun at relying on the law review article, which, I mean, yeah, they should be relying on case law, ideally. So I'm not going to worry about reading all that. Yeah, they're just talking about the article. Okay, cool. We're done with that one, I think, here. And then, all right, this is interesting. I'm excited for this one because this is objection to trifurcate. Y'all have heard me talk about this. I think trifurcating is a great idea. I'm really curious what state's going to say. I mean, we know they're objecting because here we have this. But why? How and why? Because I feel like it's a brilliant idea. State's objection to defendant's motion to trifurcate proceedings and apply rule of evidence during the eligibility phase. Hold on. I don't think that was their motion specifically. Hold on. Let me find that. Oh, no, they did say that. Okay, just kidding. I didn't remember the defense saying apply the rules of evidence, but they did. I hope that doesn't kill their argument here, that part, because I think trifurcating is a great idea, but it might be that they might not. In other words, you might be asking for too much, and they included the part about applying the rules of evidence, which I think they should, right? But I don't know. We'll see. Okay. What do they say? In his motion, defendant disregards applicable statutory authority in binding appellate decisions and instead makes a public policy argument that this court should do two things. First, he asks this court to disregard the language of Idaho Code, blah, blah, which sets forth a two-part jury proceeding. Under the defendant's proposed scheme, the trial would not be composed of a culpability in the sentencing phase, but will be split into three proceedings. I mean, I think it's a great idea. I think all the courts should be doing it, but that's just me. I understand that it's not what is normally done. It's a new idea, a novel idea, but I think it's a great idea. Next, defendant asks the court to disregard long-held precedent, holding that the Idaho rules of evidence do not apply to sentencing proceedings and to apply them anyway. The court should decline to do either. I mean, we know it's tough, right? Because we know how the courts are and how reluctant they are to make changes, even if changes need to be made. So Idaho Code provides for a single sentencing proceeding in capital cases. So they're not going to go, I mean, it's really kind of a shame, right? Like they're not going to go through and actually say how the reasoning behind wanting to trifurcate it isn't good. They're just going to be like, here's all the case law that says this is the way it's always been done. It's just it's a shame, right? It's a shame. Here's the precedent. Here's the precedent. Here's the precedent. Here's the precedent. We don't have to even address anything that was raised. Here's the precedent. It's annoying to me. But I get it. This is how it is. Another problem with defendant's proposal to trifurcate proceedings is lack of clarity as to how, as a practical matter, the presentation of aggravating and mitigating evidence would play out. Defendant asserts the eligibility phase is akin to a guilt phase in that the state bears the burden of presenting evidence supporting each statutory aggravator it seeks to prove. Thus, under the defense proposed model, statutory aggravating evidence would be introduced and admitted during the second of the three phases. Later in his brief, the defendant asserts the third phase, the sentencing phase, in which the jury determines whether death is appropriate punishment, would be conducted like a regular sentencing proceeding, which the rules of evidence are not applied, and other rights, including the right to confrontation, are limited. All the evidence and aggravation that the state seeks to introduce is applied in the final phase for the purpose of determining an appropriate sentence. Defendant goes on to explain that mitigation evidence would not be heard until the final phase of the trifurcated proceedings proposing. In contrast to the eligibility phase, the sentencing phase in which the jury decides whether the death penalty is appropriate is more like a non-capital sentencing determination. At this phase, it is the defendant's burden to present mitigating evidence and the sentencer's role to decide the appropriate punishment. Unlike evidence of statutory aggravation, which must be proven beyond a reasonable doubt, mitigation does not need to meet its burden. The jury does not need to find that the mitigation outweighs the aggravation beyond a reasonable doubt. The jury considers both statutory and non-statutory aggravation in making its determination. Thus, under the defendant's proposed model, the jurors apparently would render a decision on whether or not the defendant is death eligible after hearing the state present statutory aggravators without hearing mitigation evidence from the defendant. It'll be interesting to see how they explain. It might be that they can, when they have the hearing about this, I think it's on November 9th. It'll be interesting to see how they discuss this. I think this is their strongest motion regarding it. Like, in other words, what I think personally, whether about the motions to strike the aggravating factors and the death penalty in general, setting all that aside, right? In terms of, what case law was the defense able to provide, right? Apparently not very much. Stuff like that. Like, these are arguments that have already been made, blah, blah. In terms of striking any of the aggravating factors or any of the motions that we've read so far, I don't know they're going to go anywhere. However, I think that of all of these death penalty related motions, one to me that has the biggest chance of succeeding is this one, because it's not getting rid of the death penalty. It's not striking it all together. It's not striking the aggravating factors. It's saying we should trifurcate the proceedings. It's almost like a compromise, right? In a way. It's like, and I think they even said that at one point in one of their motions, that if the court decides not to strike any of these aggravating factors, if the court does not, strike any of these grounds to seek the death penalty, like the ones we've already covered, that if it still is going to go through with it, like, it should be trifurcated. Like, it's like a compromise, right? So to me, this has the strongest chance of succeeding. And I think it's a good, I've talked about it at length. I'm not going to go over it again, but, I think there's a lot of reasons why this is a really good idea. And I would love to see this happen. And I would love to see other courts also adopt this idea. And it'll be, so anyway, my point was just to say that when they do have the hearing, it wouldn't surprise me if the vast majority of their oral argument from the defense is spent on this motion, to trifurcate, because I think it's their best bet. And I'm excited to hear what they say. It is difficult to see how the model proposed by the defendant would benefit him in this case, where one of the statutory aggravators arises from Idaho Code blah blah, which looks to whether the defendant by his conduct, whether such conduct was before, during, or after the commission of the murder at hand, has exhibited a propensity to commit murder. Oh, the propensity again. Which will probably constitute a continuing threat to society. It defies common sense to believe that defendant would benefit from a trifurcated proceeding where the jurors would consider whether he poses a risk of future dangerousness and is therefore eligible for the death penalty without hearing all the mitigation. Yeah, I think they're misunderstanding something. And that's why I'm thinking it'll be cleared up when they have the hearing. Though not binding on this court, the potential unintended consequences of adopting defendant's proposed model were recently highlighted by post-conviction counsel for the defendant in State v. Renfro, which to the state's knowledge is the only capital case in Idaho where a court chose to adopt a trifurcated proceeding. Interesting, so it's been done before. In that case, defense counsel moved for a trifurcated proceeding based on nearly identical arguments. Interesting. However, in a subsequent petition for post-conviction relief, post-conviction counsel argued trial counsel's request for a trifurcated proceeding constituted ineffective assistance of counsel. Interesting. While trifurcation can, in theory, benefit a capital defendant, it can also carry substantial risk of overemphasizing and front-loading negative aggravating evidence without a concomitant emphasis on mitigating evidence if not properly implemented. Simply put, trifurcation is a means to an end, not an end. It is well settled that the rules, look at this, bold italics. Oh boy, they really don't want the rules of evidence coming in here. But yes, I mean, they're not wrong. A defendant, as the defendant straightforwardly acknowledges in his brief, the Idaho Supreme Court has held that the rules of evidence do not apply at capital sentencing proceedings, blah, blah. And this really comes down to the victim impact statement. You guys know how I feel about that. Like, and again, with the whole thing with the law review articles. All right. Okay. I think we get the idea. So what do we have next? Oh, there's a raccoon in my backyard. How cute. So my neighbor, you might be wondering how I can see it because it's dark out. My neighbor has we have a so cute raccoon. Raccoon is looking at me. We have, oh my God, there's a whole family. Oh my gosh, this is so cute. This is so cute. A whole family. Oh my God, they're so cute. So I have a big backyard, and my neighbor's backyard is right next to mine, and there's no fence. So the backyards are like, animals can go across, right? And there's a lot of animals out here. And anyway, but my neighbor has a garage, and he's really big on like security stuff. So he's got like tons of motion censored lights that are really sensitive, like floodlights and other lights and lights everywhere that are really sensitive. And so literally the way that I know there's animals in the backyard is because, where I'm standing right now, my window is facing the backyard and it's dark out, can't see anything. But as soon as that light comes on his garage, I know that there's animals out there because, yeah. So there's a whole family of raccoons and they're very cute. Okay. But it's nice because the fact that the light comes on and off, it's like that light alerts me. It's like I automatically, even if I see it out of my peripheral vision, I know there's cute animals out there. So go look. We have like red foxes and obviously deer, bunnies, squirrels and stuff. But yeah, the red foxes are cute and the raccoons. And then I also have, as I call it, my backyard falcon, which has visited recently. I don't think the falcons come at night though. Anyway, so next we have oh wait, I need to go to the states. Okay, here we go. Objection standards of oh my God, that raccoon is so cute. Okay. Alrighty. I mean, that's actually why I face this window. Like this is where I am all day, whether I'm teaching or whether I'm live streaming, because I can just see the backyard at all times and just watch all the animals. Anyway, all right. State's objection to the defendant's motion to strike state's notice of intent to seek the death penalty on grounds of contemporary standards of decency. So we're on to the standards of decency. Let me go ahead and X out of the ones we're done with. Okay. The crux of defendant's argument is that there's been a major shift in public opinion regarding the morality, decency, and humanity of the death penalty. Defendant suggests this shift has taken place among the states internationally and among religious and professional organizations. Because of this shift in public opinion and the alleged downward trend of the application of the death penalty, defendant argues that the punishment now violates modern standards of decency, ultimately deeming the death penalty cruel and unusual punishment in violation of the 8th and 14th. Again, there's another typo. Amendment to the Constitution and Articles 1, Section 6 and 13 of the Idaho Constitution. Okay, when considering whether a punishment violates the 8th Amendment, the court first considers objective indicia of society's standards as expressed in legislative enactments and state practice to determine whether there's a national consensus against the sentencing practice at issue. Next, guided by the standards elaborated by controlling precedents and by the court's own understanding and interpretation of the 8th Amendment's test, history, meaning, and purpose, the court must determine in the exercise of its own independent judgment whether the punishment in question violates the Constitution. The defendant argued that, quote, our evolving standards of decency, which mark our progress as a maturing society, no longer support the death penalty as an acceptable sentencing option. I mean, I agree with that. citing the increasing number of states that have abolished death penalty or issued memorandums. You know what? I bet what they're going to be like is, hey, it's allowed in Idaho. So there you go, right? It is difficult to regard a practice as objectively intolerable when it is, in fact, widely tolerated. Is already been ruled upon by the Supreme Court. Yeah. Okay. They're just such party poopers. You know what I mean? That's how I feel about it. So, all right, next. The speedy trial one. Okay. Oh, and I was initially right. Remember when I thought there was 5 aggravating, statutory aggravating factors? I was right. There is a 5th one. It's just that it was out of order, but it's coming right up. I thought, see, in my mind, I was like, I know there's 5. Why am I only saying 4? Okay. There we go. Where's my mouse? So, shout out to Iowa's Backyard, who's somehow sleeping but also typing in the chat. Very good at multitasking. Excellent. All right. State's objection to the defendant's motion to strike the death penalty on grounds of state. By the way, the squirrel pictures, oh my God, I can't even. I just, it's too much for me. I had like an actual heart attack of cute overload with that, by the way. And I'm forgetting her name. What was her name? Oh my God, she's so, I can't even. It's too cute for me. She was so cute. Okay. State's objection to defendant's motion to strike the death penalty on grounds of state speedy trial. Right. Okay. So this was an interesting one when we covered it because I was like, speedy trial, no way. Like, really? But, you know, they're doing it. So, and essentially what it comes down to is like, what they're saying is like the speedy trial, you know, rules don't allow extra time for death penalty or something like that, if I recall. His argument rests entirely on the inaccurate premise that the Idaho Constitution sets a hard and fast 6-month deadline for his trial. Does it not, though? So they're just talking about when speedy trial starts. I don't know why they feel like that's relevant. This is interesting. Defendant attempts to free himself from this well-settled case law simply by opining that the Idaho Supreme Court has wrongfully deviated from the right to a speedy trial as it was defined by the framers. Oh, the framers. I love it whenever they shout out to the framers. Am I right? He pleads with this court to hold the decisions of the Idaho Supreme Court were wrongly decided. He asks this court to instead side with the legislatures of other states and draw a firm line at 6 months. What? Unfortunately for the defendant, that's not how dude, they're spicy in these objections. Unfortunately for the defendant, that does not have constitutional interpretation or the law generally operates. Oof. This Idaho Supreme Court has been and remains the final arbiter of Idaho rules of law, both those promulgated and those evolving decisionally. So every time I see them use the word arbiter, all I can think about is the show Parks and Rec. The episode where Ben makes his game, The Cones of Dunshire. And for anyone who hasn't watched this, they're like, what are you talking about? But I would pull up the clip, but NBC would copyright me into oblivion or whatever, copyright strike me. But anyway, if you do like a search for Cones of Dunshire, I'm sure you find the clip. But it's just really funny. So he's describing this game, and this game is like so complicated and complex and, you know, whatever. But anyway, it's funny. And then he gets to he's describing the characters and he goes, the Arbiter, and he says it really funny. And anyway, I can't do the impression, but in my mind, every time I read Arbiter, I'm hearing Ben from Parks and Rec say the Arbiter in the way that he says it. So I just had to get that off my chest. Once defendants fatally, oh, the spice. Once defendant's fatally flawed premise is corrected, dude, his alleged Hobson's choice between the right to a speedy trial and the right to effective assistance of counsel is not a choice the defendant has to make at all. In fact, Okay, thank you for answering my question. It was squeaky. I thought it was squeaky. I just didn't want to get it wrong. Oh my God. Oh my God, it's so cute. Oh, how cute. I don't think I've seen that picture yet. Have you posted it? Squeaky trying to get her food. Oh my God, I love it. Cute. The choice is right. Okay. In fact, the Idaho Supreme Court has expressly held that a constitutional permissible reason to delay trial so that defense counsel has adequate time to prepare. The delay for trial preparation merely results in a trial that is less speedy and does not preclude the possibility that the trial can satisfy the Sixth Amendment and the Idaho Constitution. While it is true that a defendant misses out on a statutory benefit of a 6-month deadline for trial when he takes an action that results in the delay of his trial, defendant has not asserted the loss of a statutory benefit as part of his argument. Even if he had, there's nothing impermissible about forcing a defendant to choose between a statutory benefit and a constitutional right. Really? There's nothing impermissible about forcing a defendant to choose between a statutory benefit and a constitutional right. Huh. I don't know. I don't like that at all. A compulsion to choose between two advantages where the compulsion does not force the defendant to forfeit any constitutional entitlements is not contrary to or an unreasonable application of U.S. Supreme Court precedent. I don't like this, guys. What? What? Here, defendant chose to waive all his speedy trial rights. He did so in writing and after consultation with his attorney. There was nothing impermissible, much less unconstitutional about his waiver. I mean, I was surprised when they went to make the argument about the speedy trial. By they, I mean the defense. However, I don't think that the state has made any good arguments in their objection to it. So anyway, we'll see what happens at the argument for it. So, oh, it's not posted yet. Okay. Okay, what is next? What is next? Boo-doo-doom, boom, boom. Another one bites the dust. Boo-doo-doom, boom, boom. Oh, yes, we're on to the fifth aggravating factor. Woohoo! Here it is. Here it is. Here's the one. This is the one that was missing from the bunch. And I was like, I thought there were 5. Well, there were. See, I can count after all. All right, here we are. So this is the 5th aggravating factor. Sorry, let me clarify. Statutory aggravating factor for the death penalty. Here it is, felony murder. This might be the one, well, there's been a lot of circular reasoning. This might be the one that had the most circular reasoning. We'll see, because as with all these documents, as soon as I get into it, I remember, oh yeah, I remember what the defense's motion was about. So, all right. Oh, what? Holy shit. What? Okay, hold on. Okay, on September 5th, 2024, the defendant filed his motion to strike for, right, and we read that. Contemporaneous with this objection, the state has filed. Oh, okay, so this is, all right, this is not an objection, this is a response, right? So that makes it different than the other ones. The state has filed a motion for leave to amend notice, along with an amended notice. Under the amended notice, the state will no longer be pursuing the felony murder aggravator. Accordingly, the defendant's motion to strike the felony murder aggravator will be rendered moot and should be denied. That is interesting. Guys, you might have heard it here first. I hadn't seen this anywhere yet on the internet from anybody covering any of this, but here we go. The state is no longer pursuing the felony murder aggravator. The state is dropping that. So they are doing away with it. They've chosen to not do it. Interesting. So, so they're only going with 4. So just to review, there were 5 statutory aggravating factors that the state was seeking for the death penalty. It was multiple victims, future dangerousness, hack, which is the heinous, atrocious, cruel, utter disregard for human life, and the 5th was the felony murder aggravator. However, they're dropping that 5th one. They're not seeking it anymore. No more felony murder aggravator. Interesting. Interesting. I want to know why that is. That is very interesting. They're dropping it. Well, that's a win for the defense. That's a win for them. That's a win for Kohberger, right? That's a win. So next we need to pull up this whole thing about the okay, so this is what they just referenced here. Was this. Okay. So see what I mean here? Motion for leave to, hold on. Can you guys see what I'm saying? Yes. Okay, motion for leave to amend notice, this whole thing. So now we have it here. Okay. Okay. So okay, I see what it is. So the following statutory aggravating circumstances appear to exist. This is what their initial one was, I guess. So this is this one here. That's your felony murder aggravator. At the time the murder was committed, no, sorry, that's multiple victims aggravator. At the time the murder was committed, the defendant also committed another murder. Murder was especially there's your hack, there's your utter disregard, there's your future dangerousness. And so you'll notice that the felony murder, because remember, we said there were 5, right? That's not on here anymore. In other words, they're updating their notice of intent to seek the death penalty on what aggravating circumstances, because they're getting rid of that 5th one. So that's what this is about. So they have to refile this, right? So then you have this one going in order here. Okay, motion for leave to amend the notice, right? Okay, so that's the motion for leave to amend the notice. So the way these are posted are not the order they were filed. This was filed first. This is the motion for a leave to amend the notice. This is the amended notice where they've dropped the felony murder aggravator. Okay, and then you have notice of no objection. And not a surprise, right? The defense is not objecting because this is a win for them. One of the aggravators is gone. They're like, that's great, excellent. Okay, then you have, in response to that, then you have the order. Order for leave to amend notice pursuant to Idaho code. So there it is, by the judge. So no more felony murder aggravator. Interesting. See, now I want to, okay, just because now this, I feel like I want to remember what that one was. Let me pull up the defense's motion to see what it was. Okay, here it is. So many tabs all over the place. Okay. So here's the, wow, it's like really zoomed in, isn't it? Okay, there we go. Issues, whether, yeah, this was the circular reasoning to the max one. This was I thought that was the case, and it is. Yep. Whether felony murder can be predicated, right. This was a mess. I remember this. When I say this was a mess, I mean this aggravating factor is a mess, not their argument was sufficient, and that's why the state dropped it. Whether felony murder can be predicated on a burglary itself, predicated on murder. I mean, it's y'all. Okay. Remember, he's charged with burglary. Okay. The burglary isn't the way you think of burgling, right? It means intending to commit a crime. And actually, they're going to discuss it here. So whether felony murder can be predicated on a burglary itself predicated on murder, whether malice aforethought murder can be aggravated by a burglary predicated on the same murder. Yeah, it's a mess. So here's the first issue. Felony murder cannot be predicated on a burglary predicated on murder. It is impossible to charge felony murder on the basis of a burglary with the intent to commit the murder in question. The state has given notice that it intends to show the murders in this case are aggravated because the murder was committed in the perpetration or attempted perpetration of a burglary, and that the defendant killed, intended a killing, or acted with reckless indifference to human life. In count 1, the state charges that Mr. Kohberger committed burglary by entering a residence with the intent to commit the felony crime of murder. You guys see the problem here? In other words, the state seeks to prove the aggravated circumstance of this murder by showing intent to commit murder at the time of entry. The concept of committing a murder in furtherance of a burglary. So that's what it is. It's committing a murder in furtherance of a burglary. It's like from the way I understand it, that burglary charge that they have for him, it's like saying that you burgled to murder. You didn't murder to burgle, if that makes sense. And the felony murder aggravator is if you were murdered to burgle. In other words, in order to further a burglary, you had to murder. Let's say the example, I'm just going to give an example. Like, for example, let's say you are, again, it's not the definition of burglary, but just to use an example, let's say you're a bank robber or something, okay? Or a jewelry thief. Okay, let's go with that. And you expect the jewelry store to be empty, but like it's not. And so you kill someone because you're trying to get away with like the crown jewel. I'm making all this, right? Like a cartoon. You know, Matt, you got your black trash bag or sack, what have you, you know. Anyway, you know, so in other words, that would be the murder in order to continue to burgle situation. So the issue here is that, again, the way his charges are, it's like he burgled with the intent to murder. Murder was the plan. In order to do the murder, he had to break and enter, essentially, right? He had to burgle, versus the other way around. So that's what this is about. So that was so they dropped it. Well done on the defense for that, though. Okay, so then what I was going to do is, so we only have, though, looking at, there's all these court filings that came through. We've covered everything except for the court filings that relate to expert testimony. Let me just pull it up. I know I said I was going to cover them on a different stream, but let me just see, because now we're so close to having covered all of it, that now I'm like, well, you know. Let me just close out of some of these tabs because it's just a bit much. Okay. State's objection to expert testimony from Eliza Cover. So she was going to be an expert in support. So if she's not stricken, we will hear from her at the hearing on November 7th. And her job is to offer expert testimony to support the defense's motion to strike the death penalty on grounds of arbitrariness. Professor Cover's testimony would not be helpful to this court. Okay, well, since you said so, I guess you're right. All right. Oh, boy. It is now well established in Idaho that testimony containing conclusions of law by an expert witness is generally inadmissible. As the Idaho Supreme Court has explained, when an expert witness offers a legal conclusion, okay, well, is that what she's going to do, though? Oh, I wonder if these experts that they're referencing here are the people who wrote the law review articles that they kept teasing By they, I mean the state kept teasing. They kept teasing the defense, saying that they're relying on these law review articles, and they kept kind of, making little comments. I wonder if these are the authors of those articles. That would make sense. That would make sense. This means that courts must review both the expert's qualifications and the records relied upon by the expert to determine whether the expert can establish the necessary foundation. Well, obviously, duh, we know. Professor Cover did not have access to sufficient information to determine whether each of the defendants mentioned in her article were legally eligible for the death penalty. Okay, so that's her. And then I think they said it was a her. And then Barbara Wolf, MD. So they would bring her in as an expert for motion to strike on grounds of vagueness. My guess then, this is the one balancing aggravators and mitigators. That's the one that ends up talking mostly about, from what I can recall, the different methods of execution. And this is an MD. I wonder if this would be talking about that they still live and they're still in pain, and remember, as I mentioned earlier, about being shot in the heart, it's just horrifying. I wonder if that's what Dr. Wolf would be doing. Oh, but they don't even give us enough information to let us know if that's what it was. Gosh darn it. They're just saying it's not right for judicial determination, so it's irrelevant. Dang it. I think there might have been, though, an affidavit. Let me see if there's an affidavit. There might be. Expert witness disclosure. Okay. Let me see if this is it. Yep. All right. So I'm curious. Oh my gosh. Go there. Okay. I'm curious. So I didn't cover this one because, and I'll tell you why. Because what happened was when we had the other hearing about the motion to change venue, they had that memo that was like 50 gazillion pages, and it had the expert witness, had like, basically it was like a preview as to what their presentations were going to be. And I covered like pretty much all of it. And then what happened was they had the hearing, and I was like, well, now this is all redundant. Like, I didn't need to do all that, And so then when this document came up, I think I said it on a live stream. I even said, well, this document came up, but like, I'm not going to do it because it was redundant last time. So I didn't cover it. But this is the document that has the expert witness disclosure for Barbara Wolf. And I'm curious what but now I want to just take a look and see. I want to see what she does because they want these witnesses struck. Okay, here we go. Here we go. Barbara Wolf, MD. Let's get to know what she's talking about because they don't even address it. The state is just like, it's not right. That's it. So we don't really learn anything from that. Okay, it's long. I guess I can scroll faster than I initially thought to get to the exhibits. Wow, she's done a lot of stuff, that's for sure. Oh my goodness me. Wow, she's a busy person. Wow, it's a lot of stuff. Oh, it's not, doesn't have it. Oh, dang it. Is it just the CVs? Is that all this is? Yeah, her CV is way longer than this lady's CV. That's it though. It doesn't have like interesting. So no, so yeah, so my thought was right. The spaghetti bullet difficulties inherent in the. I mean, this is what I was. My thought was that she's gonna would be talking about the thing that depresses me, which is the issues with firing squad or the lethal injection, the pain and the suffering and the how long they live. Like that's what I assumed. And I just wanted to see if we could get any insight into that, and it seems like that's correct. Although it looks like she's talked about a lot of different stuff. Holy crap. Wow. Methadone-related deaths in Palm Beach County. Wow. Wow. Co-sleeping and sudden unexpected death in infancy. Interesting. Wow. She's done a lot of, like, she's got a really diverse, what's the right way to say it? I guess that, but identifying characteristics of tattoos. She's done, like, she's very well-rounded. That's not even the right word. Like, wow, though, for a doctor, though, to like have this much different, I can't think of the word, HIV. I mean, goodness, she's written stuff on like all kinds of things. What is the word I'm looking for? She's very prolific. That's the word. That's the word. Prolific. Bone marrow. Holy mackerel. Well, I hope they don't strike her because I want to hear from her. She seems really smart and knows a lot of things. Non-Hodgkin's lymphomas. I mean, geez, Louise. Okay, so I think though, okay, so what was I doing? So we were looking just to see if there was anything else in terms of the new court filings, and then I got myself not really sidetracked, but the state is wanting to, what was it? How do they say? They are objecting to the expert testimony from these two experts, okay? And then the only thing left really here is there's an amended objection. That's the last thing of note. Okay. Amended objection to expert testimony from Dr. Kohberger. Oh, they're changing their argument. They're saying, is that interesting? Testimony containing conclusions of law by an expert witness. All right, no, that's not a different argument. That's the same argument. Right, that she can't be making conclusions of law. It doesn't have foundation. Well, let me see. Where was that was that one. It's this one. That was this one. Okay, so this is the initial objection to Dr. Kohberger. Here's the amended one. Interesting. So, well, for one thing, one difference is they got rid of this. Well, I remember when I was like, the spice. Because this sentence right here, Professor Kohberger's testimony would not be helpful to this court. That's gone. They got rid of that. Anyway, we don't need to go through and see what all the differences are, but they amended it. That's the last document, though. Let me just make sure, but I'm pretty sure that was the last thing. The only other thing was like certificate of delivery, and then about how you can request case records. We don't need to read those. There's not anything of note there. So that's that's everything. That's it. That's all the documents. We did it. Yay, go team. That was a lot. So we did it all though. We did it all. So that's it. There you have it. So big key takeaways. Well, there's a lot. I would say the biggest one, first and foremost, is that the state's dropping that 5th aggravator, the felony murder aggravator. Now there's only 4. That's a big one. Another big one is that state is objecting to the expert witnesses that the defense wants to bring in for the hearing on November 7th. We don't know yet what's going to happen. So far, we just have those objections. And those were just filed yesterday, I think. So we don't have anything else about that yet. And then I guess another one of the big key takeaways for me was that the state seems to be kind of confused about what the defense intends in trifurcating the proceedings. And it might be that there can be clarification that will be gleaned from when they have the oral argument on that. And then there were probably some other key takeaways, but that's what comes to mind first and foremost in terms of new information from today, from these documents. Pretty sure. So anyway, but that is it for this one. So I'll get going on timestamps for everybody that's on replay crew, rewatch crew. I do think the next episode of the Florida v. Anthony will be probably on Monday. The challenge I have also for me right now is that I filed for an extension on my taxes because they're such a pain in the butt and I hate doing it. And that is due the 15th. Oh my God, that's in 2 days. So I have to get that. I don't even know what I'm talking. I have to get that done. And so anyway, the video is already done. It's just when I do the stream will kind of depend on, what I need to do is get the taxes done first and then do the stream. So anyway, so we'll see, but it will be soon. Either Monday or Tuesday. If I can get my taxes done soon, then we'll have it on Monday. But anyway, that's pretty much it. So as always, I will keep you guys posted with any new information and court filings out of Idaho. And yeah, thanks everybody for being here and for being a squirrel. Love you guys and see you next time.